Hello, welcome back. This is Roger Royce with the 10,000 Startups podcast, where each week we bring you original content from an industry expert on a topic of interest in the legal world for startups. I'm also a partner with Haynes Boone in Palo Alto. I do emerging growth and venture capital, and a big part of my practice is M&A, which is why this week I'm really excited that we're going to talk to two people from SRS Acquiom about the M&A markets. Drew Fowler is a director of business development. He focuses on West Coast clients and provides subject matter expertise on FX solutions. Um, that tends to be his background. But now with SRS Acquiom, he's focusing on the M&A markets. Kip Wallen is a senior director of thought leadership through SRS Acquiom, and he has extensive experience in the SRS proprietary data where they produce content that's often used by practitioners like me in understanding what are standard terms in M&A and where the market's going. So Kip and Drew, I want to thank you for being here and welcome you here to the podcast.
Yeah, thanks for having us, Roger.
Yeah, thanks,
So
Roger.
Drew, can you give us a quick, maybe 1 minute overview of what SRS Acquiom does?
Sure. Yeah, happy to do that. So what we do here at SRS Acquiom is we offer pre and post closing solutions for private target M&A as well as loan agency solutions. So our goal is really to streamline the M&A process from the very start to the final payout with virtual data room, paying agent and escrow agent services, and professional shareholder rate. That last one we actually created. So also one of the other things that we can offer as a function of our unique role here in M&A is data. So since we see all these merger agreements, we're able to compile one of the largest data sets of deal terms in private target M&A that you're going to find. So we compile all that data, we make it available for our partners to help them determine what's market in private target M&A. They're really helping folks in their day-to-day roles when it comes to the negotiations.
Okay, great. So let's get started. Can you maybe just at a high level, can you tell us a little bit? I mean, I've been reading the data, and the financing data has not looked very pretty over the last year or two. What are things like in the M&A world, especially in terms of deal volume and valuations?
Yeah, that's a great question and a great place to start. So the last couple of years, 2022, 23 specifically, there's been a lot of downward pressure on valuations for target companies, particularly in the private target space, private target M&A. And it's just when we compare it, the last couple of years, it's most interesting or sort of dramatic when you put it up against what we saw in 2021. So those of us who are practicing M&A in 2021, right, remember it was just an incredible year for private target M&A. Valuations were sky high, deal volume was astronomical in 2021. And so it makes the current market we're in, the 2022, 23 market, feel pretty dramatically different, just because that 2021 was such an outlier year. So, certain industries feeling even more pressure in the current market on those valuations, right? Like tech targets, particularly taking a hit. And it's led to deal parties having to think through the financial engineering of these deals and really get creative and find ways to make these deals happen. So even though there's not as many deals happening, we're seeing really interesting trends in the deal terms around how parties are making those happen.
When you say trends, what does that mean? And well, let's talk about the trends. It just seems to me I'm seeing more private equity in the market more and more every year, it seems. Is that just my imagination, or is private equity taking a bigger role here?
Yeah. So, the kind of breakdown between financial buyers like private equity firms versus, strategic buyers like the large public companies, it's always interesting because we see both types of buyers every year. You're right about that, Roger. But it does tend to shift a little bit year over year. So in 2021, we saw just immense competition from all buyer types. Kind of everyone was pretty involved in the market back in 21. In 2022, we did see more of those financial buyers. We saw a little bit of an uptick in private equity buyers making direct acquisitions, those portfolio companies, right, sponsored back companies doing those bolt-on or add-on transactions. Last year in 2023, interestingly, it was a little bit more of a shift towards financial buyers being active. So more of those large strategics or the independent or non-sponsor backed private companies being a little bit more active on the buy side. So it does tend to year over year, it can kind of shift a little bit. So far in 2024, I think we are kind of seeing more of those private equity and financial buyers a little bit more active in the market. I know, Drew, that I think that's what you're seeing in kind of the deals that we're hearing about so far this year. Is that right?
Yeah, Kip, that's definitely right. So in 2024, I would say Q1 deal volume definitely remained low, but definitely in this last month and a half, I would say both financial and strategic buyers have been active so far. We're even seeing some auction processes come through, which might suggest a little more competition among buyers for certain target companies.
Interesting. Well, that's significant in my world because it oftentimes defines a lot of what the deal is going to look like, especially in terms of the currency that gets used to make the acquisition. I'm typically on the sell side, and a private buyer and a strategic, or private equity buyer and strategic, those deals tend to be different, and they tend to look a little bit alike with the private equity. So let's talk about some common deal structures that we're seeing come up. First of all, obviously cash, right? And that's kind of for a seller, that's the best thing maybe you could do, is to just get as much cash as possible. That's what I counsel my clients. Can you tell me what some of those different structures are, and if we're seeing any trends in terms of how deals are being structured?
Sure. Yeah, there absolutely are some interesting trends going on with the consideration mix on these deals. So, of course, in private target M&A, cash remains king. The majority of deals are still cash deals. But the last several years, really starting in 2021, we've seen a heightened use of buyer equity as part of the consideration mix. So a little bit of a pullback on all cash deals. Buyers, in 2021, motivated to use their own equity because the stock markets were having a very good year. And so buyers just had very high value stock. The last couple of years, probably the heightened use of equity driven more by the fact that cash is expensive right now. If you're doing a leveraged deal, interest rates are high, it's expensive to finance the deal. And also buyers just may want to protect their own cash position. And so they don't want to, do too high of a cash outlay from their own coffers for a closing payment. So yeah, it's been a heightened use. There is a little bit of good news in that though. So the last part of 2023, we did see a bit of a comeback in cash deals. And I think anytime you see more of those cash deals happening, which it really was sort of the middle of Q3 last year and into Q4, that's always a good sign when we're starting to see a few more of those cash deals. Maybe that it's a little bit more of those healthy or clean M&A deals happening, and just buyers getting comfortable with the current market, and the cost of financing, things like that, to move forward with these deals.
Let me ask you about this. Do you see more asset deals or stock deals?
So so all of our data is pulled from deals where we're the shareholder rep. So we act as a post-closing representative of those selling shareholders. So most of the deals we see are structured as a merger or a direct stock purchase. We do see asset deals from time to time, probably not as many, not as high as a percent as the general market sees in terms of asset deals. Usually we're brought in if that asset deal has some sort of post-closing mechanism on it, right? An earnout or post-closing indemnification. But there were a few more. So even though we don't get engaged on those asset deals quite as often, we did see more of them last year than years prior. So that may be indicative of, we're also seeing some of that distressed or sort of sellers being forced to make a timely sale, and not having the leverage to negotiate away from an asset structure.
That would make sense, because I think there definitely more deals are done as stock deals, but in a distressed scenario or when leverage changes, a buyer would always rather buy assets. It's a little harder for us lawyers because we got to transfer a whole bunch of assets and we might not catch them all. But I can see when the buyer has leverage, that's what they'll do. Okay, interesting. The cash part, the seller stock or the buyer stock, that's interesting. Tax consequences to that, of course. How about notes and deferred payments? Is that commonly a part of the deals you see?
Yeah, we do see deals with seller notes or seller financing. Usually, deferred consideration is usually going to take the form of an earnout, meaning it's subject to some sort of milestone or performance metric hitting post-closing before it's payable. That was where it got really interesting in the data last year. We went from seeing 1 in 5 private target M&A deals having an earnout to now 1 in 3 in 2023. So just a tremendous uptick in the number of deals or deal parties, sort of again with that financial engineering to get these deals done, resorting to that earnout structure and pushing some of that consideration to the post-closing period.
Okay. Earnout structures are more earnouts or less, would you say? Is that increasing or decreasing?
Yeah, definitely increasing. And not only are we seeing more of them, but they're really highly negotiated. They're very customized provisions going into these earnouts, around what the metric is and all, whether there's operational covenant or diligence standards imposed on the buyer of how they operate that business post-closing. Just very detailed provisions. Like one example is, so an earnout may be subject to just one goal being hit, or they may have multiple triggers that have to hit in order for the earnout to be paid, or maybe the earnout is split among those various metrics. About 2/3 of deals last year had multiple triggers for the earnout structure. That compares to 58% in 2022. So more earnouts, more complicated, and more milestones per deal as well.
Yeah, and sort of a lawyer's playground. So for the audience, by earnout, what we mean is contingent consideration, and usually it comes up when the buyer and seller they might not agree on a valuation because it sort of depends on how well this business does that they're buying. So it'll be X dollars plus some other consideration based on how well we do. And the multiple triggers, it might be gross revenue, it might be net income, it might be something else. And what you're saying with the multiple triggers, you got to hit both these targets in order to earn the earnout. For example, you have to hit a revenue target and an EBITDA target, maybe, then you get the additional payment. And of course, there's different tiers. The better you do, the more you get, etc. So you can see how much mischief can be caused with those clauses. And that's why you're probably in the deals, as we all get smarter about them, you're seeing more and more covenants and definition as to what we're going to do to get there. Hey, let me ask you about another type of consideration that I see in private equity deals is just rollover. And again, is it just me or am I seeing more and more rollover consideration? And for the audience, by rollover, what I mean is the founders or the shareholders sell the company, but they keep a stake in the acquiring entity. So they're rolling over their equity into the acquiring entity. Not all of it, of course, but some percentage of it so that they got skin in the game going forward. More or less of that?
Yeah, well, Roger, so you kind of mentioned that the major consideration there is it a financial buyer or a strategic buyer? Financial buyers, right? Very, very common for them to include a rollover component on those deals. And that makes a lot of sense, right? Because if you have a financial buyer, you kind of think of them as more of an investor, right? As opposed to a strategic buyer that's buying that target for competitive reasons, right? They want to combine it with their current business operations, right? It's a strategic acquisition. Financial acquisition, the buyers probably don't want to run that business, right? They want to invest in it. They want to gain some of the upside. So oftentimes financial buyers will ask the current or existing management team of the target to stay on post-closing and continue to run that business, even though they're not the sole owners anymore, right? They know what they're doing. They're experienced. They know how to run that business. So yeah, Roger, like you say, having those managers roll over their equity into the post-closing entity aligns those interests with the financial buyers so that everyone's sort of got skin in the game. So financial buyers, much more common to see those rollovers. Strategics, we don't see it as often. And because we didn't see as many strategic buyers last year, we actually did see fewer deals with the management rollover last year. But I think especially when there's more competition among buyers and buyers are sort of wooing these management teams and teams of founders to select them as the acquirer, I think you're right. Overall, there is more consideration given to potentially adding that rollover component, even from strategic buyers in the current market.
Okay. Well, let me shift gears a little bit and drill down on I guess a more specific issue. Again, another one of the things that keeps lawyers busy is we'll price a deal, we'll sell the shares, and I'm going to talk about purchase price adjustments now. And for the audience, the purchase price adjustment is basically exactly what it sounds like. It's an adjustment based on what the company looks like at the date of close, as opposed to what it looked like when you signed your definitive agreement, or maybe even before. So can you maybe give me a summary of what types of things would adjust the purchase price in that scenario?
Yeah. So the most common we see, and this is pretty much on all private target M&A deals, is sort of a post-closing purchase price adjustment related to the working capital of the target. So, right, Roger, you're exactly right. Even when you close the deal, the target company doesn't know exactly what their working capital is. They can estimate it at that time, right? But it takes a while to close your books, right? We all know, a month or two for the accountants to close the books. So in a post-closing PPA, right, sometimes we call them working capital adjustments. If the company estimated that they had sufficient working capital, but then you get those final numbers after the fact and realize, oh, actually, they didn't have as much working capital as they thought, that can result in a purchase price adjustment where the buyer would actually get some of the purchase price back to make up for that working capital shortfall. Also, though, it can go the other way. If they sort of underestimated working capital and it turns out there was a surplus, the sellers may benefit from that adjustment amount. It just depends on how they structure the deal. So we talk about purchase price adjustments a lot because we see them on pretty much all the deals we're engaged on. In fact, I think we've resolved like over 2,400 PPAs at this point. And so there's just a lot of interesting data around it that we have. But also, it's shifted a lot in the last 5 to 7 years. These are now kind of two-way mechanisms where buyers or sellers benefit, just depending on where those calculations land. Whereas a decade ago, it really was one-way mechanisms where only the buyer would benefit. Even if there was a working capital surplus, buyer just got to keep it. And that's been interesting. I think, deal parties are paying closer attention. They're more carefully negotiating these provisions. And it's having an impact, like particularly on sell side, right? I know, Drew, right, in the sort of sell side, when you bring sell side onto a deal, we're kind of seeing that impact from sellers particularly, right?
Yeah, absolutely. I mean, Roger, like you said, this is keeping folks very busy on the lawyer side of things. I mean, deal parties are paying closer attention to this, and it really makes sense because they don't want to leave money on the table. So we push back on buyer calcs about 28% of the time when we're as shareholder rep, and we're able to reduce those buyer favorable adjustments by about $200,000 on a median basis. So really impactful cash there, right? And just as an anecdote too, it's about 8 times our typical engagement fee. So something to really consider for deal parties moving forward.
You said something really interesting there, is that these purchase price adjustments, the working capital adjustments are a two-way street oftentimes. Because I remember when it used to be that it was just, if you didn't hit your target working capital, you're going to have a reduction in the purchase price. But what you're saying is that now oftentimes if you have more than your target working capital, you get the gravy, you get the bonus, which is way more fair. As sellers counsel, I think it's way more fair.
Yeah, it's. I think buyers have sort of had to come to terms with this, and sellers have just found a way to argue. I think 10 years ago, buyers would say, "Well, it's the bargain of the deal, right? If you're the target company, you're the one that estimates working capital. If you overestimate it, right, or the way you estimate it results in a surplus post closing, that's the deal. We get like that's what we negotiated as buyer. We just get to keep it." But now they realize that this really isn't about it's an accounting true up mechanism. It's not really about kind of gaming the system. So most of these play out. They're very smooth process, right? There's not a whole lot of contention. It's just some good faith back and forth. The numbers are what they are, and so you just have to the parties work together to figure out what those numbers are.
Gotcha. Okay, let me come to another issue. Speaking of 10 years ago, and when us old timers used to do this, since over the last 10 years, one thing that's changed is the use of insurance in these deals, particularly what we call representation and warranty insurance. And we'll do a whole podcast on that one of these days. But the idea for the audience is that that's a risk that's insurable. In other words, the seller will make a series of representations and warranties to the buyer about their company. For example, we don't have any undisclosed litigation that we don't know about, or we don't have any claims we don't know about. Let's just say something easy. An employment claims that we haven't disclosed to you. And then they close and all of a sudden an employment claim pops up. So before, the seller or the buyer, however the agreement was structured, would have to take that cost. Of course, now stuff like that can be insured against through rep and warranty insurance. And that has totally changed the dynamic of the negotiation, because now you got a third party at your negotiations involved. That's the insurance company. And I think it's just a way, makes it a lot easier for everybody if you've got RWI. So my question to you guys is, how often are you seeing rep and warranty insurance in deals?
Yeah, so we see it on a minority of deals. And you're right, Roger, like the last, I would say maybe 5, 7 years, there's sort of been a lot of interest in reps and warranties insurance. Usually financial buyers are a little bit more comfortable with that product, a little bit more familiar with it. But in 2021, right, that outlier year, we did see strategics even offering RWI on some deals. But since 2021, there has been a pullback in the usage of RWI. So both our data shows, a little lower usage of RWI. I think it was about 38% of deals last year in our data set had that insurance product. The ABA, they of course put out their deal point study. Their data is pulling from agreements that are filed with the SEC's Edgar database. But similarly there, they track that data and they show a pullback in the usage of RWI. And so I think what's really going on is, RWI has been around for decades, but it gained a lot of traction in the last 7 years or so. And we're getting more data on it, right? We're starting to hear from insurers and brokers, how the claims play out, how often they're getting paid, how many claims are being made in the first place. And I think the market itself is just catching up to that data, understanding how these really work, and when they might be right for a deal versus when it makes sense to go a more traditional indemnification route. In our experience, it definitely has an impact on how claims play out post closing. And Drew, I know you've had some conversations with our attorneys on staff on sort of how those go sometimes.
Yeah, thanks, Kip. So yeah, we've heard from our post-close litigators that the RWI can sometimes add some time and complexity to things. So we're even hearing from some buyers that they're electing to self-insure because they haven't been happy with the payouts. So ultimately getting kind of frustrated in that area. So I would just say it's just really important for deal parties just to make sure that use of RWI is right for their particular deal and that they run all the traps associated with it.
Okay. You said something interesting there, traditional indemnification. So let's talk about that. And again, for the startup founders in the audience, I've mentioned these reps and warranties. You're going to make a long list of promises to your buyer about the state of your company. And if things turn out to be wrong, of course, then there's going to be some liability on the part of the sellers. They're going to have to indemnify that buyer against those losses. Now, we always negotiate caps on that indemnity because you don't want to lose money on a sale. And we negotiate all sorts of limits. You want to stop looking over your shoulder at some point. What are you guys seeing in terms of indemnification provisions and survival periods for reps and warranties?
A lot. It's very exciting that, for us data nerds like myself, it's been exciting, particularly because I think the major driving force around how indemnification terms are being structured and negotiated is the fact that the pace of deal making has slowed pretty significantly the last 2 years. There's just not that sense of urgency to get deals signed and closed, and buyers ready to move on to their next acquisition. So buyers are taking advantage of that luxury of time and conducting really thorough due diligence, right? The seller is going to open up a data room, right? Usually a virtual data room. They're going to put all their important documents in there, and buyers going to spend a bunch of time poring over that, right? Doing their due diligence. And since buyers have more time to do that, they're identifying more red and yellow, those kind of potential issues that might come up post closing, resulting in a breach of rep and warranty claim made by the buyer. And so when buyers see more of those potential yellow or red flags, they account for it in the indemnification provisions. So we're seeing a lot more carve outs to like the survival period, right? Because, like Roger, you mentioned, usually there's a dollar amount cap. There's also usually a time limit. That's the survival period. We're seeing more carve outs to those caps. So you might have sort of a general cap that's maybe 10% of the deal, but then certain things that are higher risk, the buyer may want a second level cap for that. We're seeing more of those second level caps. carve outs to the basket, which we don't have to get into what a basket is, but basically that amount you have to exceed before you start to owe the buyer for those indemnification claims. Sometimes there's carve outs to those baskets. The biggest impact, though, is we're seeing way more special escrows. So buyers, not only are they identifying these potential red flags and accounting for it in the drafting, but they're also asking for that additional security of special escrows or special purpose escrows, so that if they see, oh, there's a potential tax matter on this one, we want to pool the money specifically for that. Or there is a purchase price adjustment, right? And it's possible that there is a working capital shortfall, so we want a separate escrow as security for that. So seeing way more of those sort of very customized escrow structures, as well as just overall a lot more thought given to how the indemnification generally is structured.
Let me double click on that for just a second on the escrow. So for the audience, if you haven't been through this process, imagine that you're a buyer and you've got reps and warranties, you got these indemnification provisions in case something goes wrong. Well, what happens if it does? What are you going to do? Go sue your seller? They've already got all the money. How do you get it back? So instead, we'll put a portion aside into an escrow, and there's usually an escrow unless it's insured for like general reps and warranties. And I think what Kip's talking about is sometimes you have a specific risk that is so high risk of a claim that you set aside a special escrow for that claim. Environmental comes to mind. I've done deals where we've got a lot of environmental risk, so we have a special escrow just in case there's an environmental claim in the next 2 years or whatever. Or tax claims is another one. And those are, and I think Kip, what you're saying is you're seeing more use of escrows or pretty steady.
No, definitely more use. So,
Yeah.
we continue to see if it's sort of that standard indemnification structure, you're probably going to have that 10% escrow as just general security, right, Roger? What you were talking about, because you don't want to have to go claw back from the security holders. That is a lengthy, arduous process. No one likes to do it. Buyers, even when we're shareholder rep, right? Like that's the last thing we want to do is go ask our clients to pay the buyer back more money. But you're right. On top of those general indemnity escrows, definitely seeing more of these special purpose, special escrows. Yeah, tax is a big one, environmental issues. And I think it's important, if you are a seller thinking about, potentially selling your company down the road, it's good to know and be mindful that buyers are sort of expecting this additional security, these additional escrows. So that's why we're just seeing. I think it's over a third of deals that have these special escrows, and especially deals that have that reps and warranties insurance. There's even more special escrows on those deals because buyers are accounting for if there's any gaps in coverage or carve outs or exemptions to coverage. They want a separate escrow then to cover that potential risk since the insurance policy carved it out.
Gotcha.
Yeah,
Okay.
Kip, can I want to add to that a little bit as well. So, for the audience out there, we definitely, even though we're seeing this uptick in multiple escrows, we don't want to put the fear in there because ultimately, really, while we do have these additional escrows and additional it's not going to add additional complexity to the deal. So you're still going to be able to use one escrow agent, and it's still going to be governed under one escrow agreement. So the escrow agent should be able to help clear that up and make it simple, even with multiple escrows.
Yeah, it's a great point.
Yeah, good to know. All right. Well, with that, is there anything else that you'd like to add? Any major points or trends or comments before we close out here?
Yeah, well, one thing I would just say that's been sort of interesting for me now that it's basically my full-time job to kind of watch this data and see what's happening in the market. Usually, and historically for SRS Acquiom as well, we've been putting out our deal term study for over a decade. Usually we present things on an annualized basis, right? Looking at a full year at a time. But the way the market is now, things shift quickly and sometimes dramatically. So we're definitely doing a better job keeping an eye on those mid-year shifts and realizing, it's not just, looking at just the full year may not give you the full picture and getting into that nuance. So like, for example, last year, right, we saw more earnout deals, but generally the amount being tied to that earnout, right, the contingent consideration tied to the achievement of the earnout, that the amount hasn't really gone up. Even though there's way more earnouts last year than years prior, sellers are still you're kind of drawing the line and saying, well, we don't want to tie too much to achievement of that earnout. That's where the full year landed. But if you look at just the first quarter of the year, they actually did spike up the size of those earnouts. So maybe there were more of those distress or kind of companies that were making a quick exit in the first half of the year, and more mainline, traditional, clean deals happening towards the end of the year. So I think being mindful that, these trends can shift on a dime and throughout the year, and keeping track and keeping up with the latest data, I think can be really helpful in your negotiations and just keeping abreast of what's going on in the market.
Okay. Yeah, I think ultimately what I'm seeing really is that we're in a unique environment. And I think M&A is always going to be a unique environment. But I think what's specific about this one is just that now deal makers are more risk averse as opposed to, say, 2021. So I think even as we see deal volume increase, we're definitely still going to anticipate some thorough due diligence is going to have an impact on indemnification terms. And the deal parties are going to continue to rigorously negotiate and customize these private target deals.
Gotcha. Okay, well, I want to thank you guys for being here. This is Roger Royce with the 10,000 Startups podcast. I've been speaking with Kip Wallen and Drew Fowler from SRS Acquiom about deal trends in M&A. Again, thank you guys for being here. Roger Royce, 10,000 Startups. We'll see you all next week.
Thank you.